Welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorneys.
Hello and welcome to Navigating Consumer and Family Law Challenges, Insights from SoCal's trusted attorneys. I am your host, Kevin Rosenquist, and today I'm joined by Amanda Hill, a family law attorney who offers helpful, caring, and professional legal services and advice. And today we're going to discuss child support and how courts determine the right amount in California. Amanda, welcome back.
Hi, thanks for having me.
So let's start at the beginning here. Can you explain the basic principles behind how child support is determined and what factors are typically considered when calculating the amount?
Yes, absolutely. So essentially, every state has their own specific parameters or guidelines that they utilize in determining what an appropriate amount of child support should be. So in California, it's called the California Guideline. And that's based off of many different factors that the legislator determines are appropriate. So of course, it's going to be based off of cost of living. It's going to be based off of the incomes of both of the parents, how they file their taxes, timeshare, tax deductions. So there's a whole laundry list of different factors that go into the computation.
When it comes to income, employment and that kind of stuff, do things change when if maybe both parties are self-employed?
Yeah. So for example, it's much easier when somebody is a W-2 employee because you look at their pay statements and you can see what their gross income is and input that into the software system that's utilized to figure out what the guideline is. Now, when somebody is self-employed, you actually use the net, and it's a different factor because the courts do allow you to reduce what number you put for your income based off of what your deductions are. Now, it can get a little sticky because some of the deductions that you would take as a business owner or a self-employed individual on a tax return aren't necessarily the same deductions that you can utilize in court. So what'll happen sometimes is there'll be disputes as to what can be included as a deduction for purposes of calculating income available for support. So one example I would give that's most common is, a lot of times, depending on which CPA they're using, they may include their individual car expense as a tax deduction through their business, or gas, or, other items that technically, if somebody on the other side is W-2, they don't get to reduce their income for those things that they have to pay out of pocket. So arguably, you can say those should be added back and those shouldn't be included in the computation. So, I have been to court several times arguing over what add back should be for self-employed individuals, which are actual appropriate ones that the court should consider in reducing what somebody's income is.
Yeah, I can see how that can get kind of tricky because you're right. When you have a W-2 and you just say, okay, well, this is what the person made. You can make an educated guess on what they're going to make, and you can do this. But whereas, I run my own business, and it varies. It goes up and down, so it's hard to pinpoint where you're going to be in the next, however long the courts are going to look at.
That's actually a really good point. So interestingly enough, because a lot of self-employed individuals, maybe they have seasons where their income is higher than others, or maybe, it does fluctuate from month to month. They work in sales, things of that nature.
Sure.
What the court tends to do then is they look at year-to-date averages. So they'll look at the past 12 months, or sometimes they'll even look at the last 24 months and take the average monthly income for that individual and utilize that for purposes of figuring out what their monthly average income is for purposes of computing the child support, because we want it to be as fair as possible. And I see the courts tend to do that with individuals. Now with the W-2 employee, it's a little bit easier because you can usually see on there, if they're salaried employees, it's very simple. But again, even with W-2 employees, it can get a little bit more complicated because what if they receive commissions? What if they receive bonuses? What if they work overtime, but it's only during high season like Christmas or the holidays? So then that also becomes a situation where the court has to look at, okay, average over the year, how much overtime are you working or how much commissions are you making?
And then even if somebody has like a side hustle or something like that, if they're doing some work on the side, then that even complicates things further, I would imagine.
Yeah, definitely. But in California, all those little side hustles, they are included as income. So it's important to be transparent with the court, because you don't know how many times I've gone to court and we're presenting the income information for both of the parties. And all of a sudden, during testimony, one of the individuals points out, and I mean, this is a little bit of a spicy example, but I had this happen to me where the other side points out and says, but she has an OnlyFans account and I know she makes so much a month on it. And then they pull out, proof on their phone. And then you're kind of like, okay, well, is it true? And then, so you always want to be open and honest with the court. You don't have to share all your dirty laundry. And certainly I don't judge, but all of those side hustles, all those streams of income have to be disclosed.
All right. I'll make sure I make note of that if I ever get divorced. Make sure people know about my OnlyFans. Okay. So when it comes to modifications, if a parent claims, okay, my income has decreased significantly, there's downturn in the economy, my business is struggling, I got, demoted, whatever that is, how does the court handle those types of modifications?
So it's important for each individual to figure out whether it's a temporary change or whether it's something that's going to be more permanent. So I'll go over both different examples. Temporary changes include something like somebody gets injured on the job and they're going to be temporarily on work comp. The first thing I always discuss with my clients, if that's their situation, is can you talk to your doctor and get a real detailed, as much as possible, what the time frame is going to be that you're going to be out and what is your disability that you're going to receive. Are you going to receive state disability? Are you going to receive some sort of compensation from your employer? Because that's important to figure out whether it's worth it for you to go back to court. Because if it's temporarily only going to be a couple of months, maybe you can just discuss it with your partner or your ex-partner to see if you can make that a temporary adjustment. But I would always caution, if that's the situation, even if you're not going back to court, to get something in writing that's signed that they agree that they're agreeing to that temporary deduction. Now, if it's somebody who's lost their job or they're permanently disabled and a situation like that, then you need to make sure you file a motion as soon as possible to preserve what's called retroactivity. Retroactivity means that you may file a motion with the court, but you're not going to get a court date for several months out because that's just how the procedures work. Well, you want to make sure that you're going to get the ability for the court to modify the current order up to the month following when you file the motion. So for example, if you're in the month of February, as long as you file it by the end of February, you're going to get retroactive modified support when the court goes to make the order March 1st forward, even if you don't see a judge till June. So that's what's really important about, like, if it's going to be a permanent change that's happening, or sometimes people say, you know what, I have to go down and be reduced to a part-time employee for whatever the specific reason is, then you know that you want to make sure you file that within as soon as possible, but definitely by the end of the month.
Does the court look at why you don't have a job anymore? Like, for example, if somebody just got fed up with their boss and quit one day, does that change? I mean, obviously they can only pay what they can pay, but does the court take any of that into consideration?
That's actually a really good question. And yes, the short answer is yes. But to elaborate a little bit more, essentially what happens is the court has to look at what the reason is. So you always want to make sure you have something in writing as to the reason why you're no longer employed. So if you got fired, are you going to receive unemployment? How much is that unemployment going to be? If you chose to leave the job because it was too stressful, then you better have some mental health, some sort of note from a therapist to show that you were exhibiting very extreme, depression or anxiety or stress related to the job. Or else what could happen, so for example, the situation where a judge says, you know what, I think you voluntarily left this position and maybe you did it nefariously because you don't want to have to pay your partner as much as you're having to be paying them anymore. And in that case, the court has the discretion to impute their historical income on them if the court finds that it's appropriate.
Yeah, because I've known people that just, I don't know, they quit jobs a lot before they have another one. And it's just, they don't like authority, whatever it is, they don't get along with people, whatever the reason. But yeah, that definitely seems like it should kind of have a bearing on it in some capacity.
And then sometimes another situation that I often see, just to elaborate a little bit more, because it can be a very complex situation, is when somebody is underemployed. So sometimes what you'll see is they're going through a divorce proceeding and maybe they have a degree and they're a registered nurse, but they decide, you know what? I'm so upset with my ex-partner. I'm just going to go and work at, I know this is an extreme example, but I'm going to go work at McDonald's and I'm going to make $20 an hour and I'm not going to utilize the experience and degree I have. In that situation too, you can get what's called a vocational evaluation conducted by an expert that says, no, this individual has the capacity to make X amount of dollars a year and they're underemployed. So the court should impute what their actual capacity is when determining what child support should be.
That's an interesting point. Yeah, that makes sense. And does the person paying have any say on how it's used, how the money's used?
That's also a really good question because a lot of people get upset. I've heard it many times, well, she doesn't need that much or he doesn't need that much because I pay for the clothes or I do this when the children are in my care. But the short answer is absolutely not. You don't get to decide what child support is used for. Now, of course, in general, it's supposed to be used for, housing, clothing, but you can absolutely use it for rent because the whole purpose and public policy behind it for child support is so that when two parties separate, as close as possible, those children are living under similar situations and similar households as they were when they were a couple.
If one of the parents thinks that the paying parent is misrepresenting their income or hiding assets or not talking about that OnlyFans page that they have and is very successful, how can the parent bring that up? How can they protect themselves from being taken advantage of?
So if there's current litigation happening, what'll happen is there's this option legally to conduct discovery. So examples of discovery are issuing subpoenas to banks. I mean, we've had to issue subpoenas to Cash App, Venmo, Zelle to see how are they getting paid or where do we think they're getting paid for these, for example, side jobs, right? The other example is we can issue formal discovery where within 30 days they have to respond to producing their bank statements, their credit card statements, their household expenses to see how are they paying and surviving if they're claiming they're only making X amount of dollars. So that discovery process can be conducted. Another example is a deposition. It's not as commonly used as what a lot of people think, only because there's a high cost associated with depositions. But depositions is kind of what you would see on TV, where someone sits down with a court reporter and they're sitting across from each other in a table in a conference room and they're being asked questions on the record about their income and their background.
And in what situation, if a parent wants to modify or thinks that something should be modified because the paying parent increases their net worth or their income by a significant amount and they catch wind of it, are they able to say, hey, they're making a lot more money, they should be paying me more?
Yes. So this is a really key distinction when it comes to the differences between child support and spousal support. Spousal support, you don't get to benefit from somebody getting a higher paid job after the divorce is final. But when it comes, in general, there's always exceptions to that, but in general.
Sure, yeah, but that makes sense.
And child support, it's much different because again, the purpose of child support is really to support the children, right, that are at issue between these parties or that these parties share. So yes, if somebody gets a big pay increase, then you can go back to court and say, I would like child support to be adjusted because I believe the other party is making more money and it should be based off of the current income available to each party.
So it wouldn't be, do they have to disclose making more money or is it more just like, oh, they noticed they bought a new Porsche or they noticed they bought a big house and something like that? Or is the paying person supposed to like keep the court up to date with their income?
So the simplest way to do it, and not a lot of people know this, but whenever there's child support orders in place, once a year, either parent can send a demand to the other in writing, and it's a specific form that you use, asking them to complete an updated income and expense declaration and attach both their most recent income tax return as well as their pay statements. And they have to sign it under penalty of perjury and produce it within 30 days. If they ignore that letter and request for that information, then you could proceed to court and say, hey, I suspected they were making more money. I asked them, and in this way to provide it so I can assess it, whether I want to go back to court. They ignored it. So now I have to file a motion with the court. And then once you open up a new action, you reopen the ability to conduct discovery and demand that they produce income information.
Okay. And what are the consequences if someone fails to pay the child support?
So there are government agencies that help with enforcing it. And the main one in California, but there's also similar agencies throughout other states. But in California, it's called the Department of Child Support Services. And if someone chooses not to pay, a court order, first of all, an income withholding order can be issued, and a judge signs off on it, and that gets sent to both the state disbursement unit as well as the person who's supposed to be paying their employer. Now, if someone is self-employed, obviously you may have an issue with that. So what'll happen is the Department of Child Support Services can get involved, and when they get involved, they can track based off of your social security number and intercept tax returns. So if you're due a tax refund, they'll intercept it. You don't get it if you are owing child support and you haven't paid it. They could put a pause on your passport so you can't travel internationally. They could put a pause on your license, whether that be your driver's license or actually any professional licenses. So a good example of that is I had a fisherman who had a fisherman, like a longshoreman license that he had to have, and he got way behind in child support, and they actually suspended his license. And so we had to go to court and get that lifted, and he had to come current on the child support. So they definitely don't mess around. And the most aggressive form that they can enforce these orders is based off your social security number. They'll be able to have access in their system of whatever bank accounts you have open. And 3 times a year, they will randomly audit and can levy your bank account if it gets really bad and you get really far behind.
Yeah. So the lesson is pay your child support.
Exactly. And I guess the very most extreme one, which I didn't mention yet, is you can be held in contempt of court. You can file a motion with the court, and that has criminal penalties if you're found that you purposely did it. Like you have the money and you're just refusing to pay it, and then you can be penalized criminally.
Yeah. Which helps nobody, because then the other person's, if the kids aren't getting the money, the person's going to jail. Like, it's just, it's a horrible situation.
Absolutely.
All right. Well, thanks for joining us on Navigating Consumer and Family Law Challenges, Insights from SoCal's Trusted Attorneys with Amanda Hill. To connect with her firm, visit kandhlawgroup.com, and please like and subscribe to our channel and leave us a review. Amanda, it's always great to see you. Thanks so much for your time.
Thank you. Have a good one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.